Hello, all. Today we are going to be talking about, can social media posts hurt your personal injury case? Welcome to another informative segment of Live with Mitch with Proner, and I'm your host, Mel Maguia. And we sit down with the expert himself, Mr. Mitch Proner, a personal injury attorney with over 30 years of experience, here to answer your questions or anything interesting topics that you might find useful in the personal injury world. How you doing, Mitch?
Doing great. Thanks. Excited to present some more information for people that are interested in finding out a little bit more about their claims or potential rights if they've been injured. And I enjoy it. How are you doing, Mel?
I'm good. It's still hot and humid over here, but I can't wait for winter. I don't know if you like winter. I do.
I like them all. I like all the seasons.
Good for you.
As a motorcycle rider, the motorcycles run better when it's cold.
Yeah, they do. They get hot. You're sitting on an engine, literally. All right. Well, let's get to it. Now, before we start, just remember, folks, if you need to contact us, all consultations are free and confidential. Call us at any time at 1-800-321-1234. So let's get to this first question here. Can social media posts hurt your personal injury case? Now, specifically, Mitch, how can posts on Facebook, Instagram, or TikTok be used against you in court?
They 100% can be used. And a lot of times during a deposition, a defense attorney will say, did you post anything about your injuries on social media? Do you have any social media accounts? And you get a variety of answers. No, I don't think so. Yes, I'm on Facebook and TikTok and Instagram, but I don't think I've posted anything. But it seems like for the last, I'd say, 15 years, when I try a case, I got to tell my client, look, anything you say that you've posted in social media, they've combed through. And forget about whether or not you gave up your passwords, because they've shown up in court with my client's social media posts without getting any passwords, without getting authorizations. And my client's saying to me, I thought that was private. I had privacy settings. I don't know how they got that. Doesn't matter. So I'll give you two stories.
Okay.
One case was a liability trial. In New York, depending on where the case is, sometimes you get a unified trial, sometimes you get a bifurcated trial.
Okay.
A unified trial means you try liability and damages in the same trial. That means who's at fault and what the injuries are and how much money you get is tried in the same trial, and it's a unified trial. In a bifurcated trial, they only decide first off who's at fault. The jury won't even hear about injuries or money until they decide who's at fault.
Mm.
In the first department, it's presumed you get a unified trial. The first department is Manhattan and the Bronx. In the second department, which is Richmond County, which is Staten Island, Kings County, which is Brooklyn, Bronx County, Nassau County, Suffolk County, Westchester, Rockland, that's all second department. They bifurcate. In the third and the fourth, it's more likely it's going to be bifurcated, but not always. You'll get unified trials. Anyway, this was a bifurcated trial. Just who's at fault. They didn't hear anything about my client's injuries. The defendant had made a left turn into an ice cream seasonal store's parking lot by turning left over a double yellow line, not respecting the right of way of oncoming traffic. My client was oncoming traffic and had a collision with the vehicle that turned left over the double yellow line. Now, you would think that would be pretty straightforward on liability, but the other vehicle stated that my client was speeding. Now, if my client was speeding, then they had to observe my client. So why'd they make the left turn? But they thought that they had a shot. So we tried the case. The interesting thing was there was a witness that my client produced that said stopped after the accident and exchanged information, said they witnessed it.
Okay.
My client wasn't speeding. The witness was not a blotter witness. A blotter witness is a witness that the police officer writes down on the police report as having witnessed the accident. Now, a lot of times there are witnesses that the police officers don't write down their names. They just take the drivers and that's it, and the owners of the vehicles. And a lot of times you'll get people that give you a phone number and leave, and but naturally a blotter witness is better because the police officer was there to document, yes, they were there, they present themselves as a witness.
Right.
So my client was on the stand and the defense attorney said, did you happen to know this witness? And the witness had testified she didn't know him, and my client then testified he didn't know her, and the witness testified he wasn't speeding. I just happened to come across what happened. I was behind there. And why didn't you stop? Oh, I had to go to college, or I had a class. So then they say to my client, did you know the witness? He says, no, they just showed up. And then the defense attorney hands a piece of paper. He says, is this your Facebook account? My client says, yes. And then on the Facebook account, there was a note to the blotter witness saying, congratulations on your baby. I guess I'm going to be an uncle. Now, I'm there in court and I'm like, oh, what a stupid client I got. He had a good case and he thought he was going to make it better. Now, I still won the case. But I said to my client, what are you doing? Why would you do that? And it was obviously questionable whether or not it seemed to me like perjury, which is a crime.
Yeah.
You can't offer false testimony in court. This is probably going back 15 years. He was a young guy and he thought he was a wise guy.
Yeah.
Anyway, people think they figure it out, and I try to tell them, just be honest.
Yeah.
We can win the case with the real story.
Yeah.
But just recently, I had a case that my client was a bodybuilder, and he suffered a broken pelvis. And we ended up getting him $2 million, a little bit over $2 million. But the defense put up photos of my client working out in the gym because he had posted that. And his social media posts, the defendants got it. They brought in like 25 photos, and I made an objection, and the judge limited it to just 2 photos.
Oh, wow.
I had to explain it in my summation, but the judge could have let all 20 in. And so when my clients say to me, will whatever I post on social media, can it hurt my case?
Yeah.
I say FAFO, fool around and find out.
Oh, I was going to ask you, what's that? Okay. That's new to me. Sorry.
It's another word other than fool around.
Okay.
But this is a family program.
Yeah. I like that. Actually, that's a perfect lead up to I guess the next portion of another question here. Should you stop using social media entirely after an accident?
I've had clients post things and defense bring it up, And the way I explain it to a jury is this. Somebody says, let me take a photo. And when somebody says, let me take a photo, we all smile. Does that mean we're smiling like that all the time? No, you don't see people walking around grinning like idiots. That's not what we do. But for a photo, we smile. So somebody could be in terrible pain and they bring out the camera and you go, that doesn't mean they're having a great time or a great life. They just smiled for a photo.
Right.
And everybody knows that everybody's out there nowadays and they're posing on social media. And that doesn't mean that that's their life.
Right.
And the truth is, with an injury or an illness, people have good days and bad days. Somebody could be on borrowed time because they've got cancer, some terrible illness, but they spend like an afternoon with their family and they say, yes, that was the last nice day they had. Right? And they spent 2 hours with the family. Yeah. Well, before they were ill, they could do that all for a whole weekend.
Right.
Or a week-long family vacation. And carry luggage and everything else. So a social media post doesn't show the whole picture. But I've seen videos of my clients where all they're doing is taking out the garbage.
Right.
Or bringing in groceries from their car. And it raises the thought in a jury's head or an insurance carrier's head, maybe this guy isn't as disabled as they say they are. Look, here they're doing normal activities, not smiling for social media, but just walking around. So, I always tell people, live your life.
Yeah.
We'll let the case present itself. If it's a real case, we'll get real value. If it's a phony case and you get caught making something up, well, you shouldn't be bringing a phony case anyway. That's insurance fraud.
Yeah.
But if social media is a big part of your life, live your life. Because you're not going to get another one. And having a happy life is more important than any money you're going to get from a lawsuit.
Yeah. And I really do appreciate that's like a consistent message with you, is that you really are concerned about your client's happiness and doing the right thing. So that's, I thank you for that. And I'm sure your listeners do appreciate that. Let me continue on with the next portion of some more questions related to this. Can liking or commenting on posts related to your personal injury affect your case? Like if you're commenting on just whatever, whether it be on your own case or just your friends.
I don't think I've ever seen just liking something that somebody else posts. I don't think I've never seen that as a introduced as evidence. Typically, so the rule is everybody from watches TV or movies about lawyers may have heard the expression hearsay. Objection, Your Honor, hearsay. So hearsay is by its definition an out-of-court statement to be introduced in court to prove the truth of the matter asserted. That's the legal definition.
Okay.
But what it means is basically when somebody says something to someone else, that's typically not admissible unless it comes in under one of the exceptions. So you could think of it as the open mouth insert foot rule.
Okay.
If I want to say the driver of the other vehicle said they were drunk and they were speeding, well, you heard that out of court. And you're looking to introduce it in court to prove the truth of the matter asserted. But an admission against interest is an exception to hearsay. So they were drunk and they were speeding. Well, that's an admission against interest. It's an exception. It comes in. So if you say something that can be used against you, they could bring it in.
Okay.
If If it's something that is written in a hospital record, that's hearsay, but there's an exception for the business record rule, and hospital records come in under the business record rule. So hospital records are admissible. So there's different rules, but liking what somebody else said probably wouldn't come under any exception to hearsay.
Okay. Okay, that's good to know.
So it probably wouldn't come in.
Okay, so it's not as all right. Great information. Well, let's continue on with the next portion of the question of the topic. I know this is gonna be kind of broad, but how can you protect yourself on social media while your claim is going on? Let's just like, for example, let's say if your job is you're a YouTuber and that is your job. I mean, there are a lot of people out there who are making where their job is content creators. Like, what could they do in that case?
Well, whenever they get on YouTube, they should have a big neck brace on. No. I'm kidding. Wrapped around like a mummy. No. I mean, if you're gonna film yourself on YouTube like tumbling and jumping out of buildings, then don't give a deposition and say you can't tumble and you can't jump out of buildings. But on the other hand, you could still have a claim if maybe you could only do that once in a day and you used to be able to do that 5 and 6 times a day.
Right.
So I think the most important thing is if that's your job, do your job, but don't say you can't do that.
Okay.
You're always better off presenting your claim as is rather than trying to fight the image of you as a liar.
Yeah.
Because there's also a principle in court that the jury's actually here. It's called falsus in unum, which means somebody who's going to lie about one thing might be more likely to lie about a lot of things, but not necessarily. But the jury actually hears that charge. So you never want to be caught being a liar when you present your claim.
Okay. Well, that's once again great information. I know this is kind of it's not that new. I know social media has been around for a while, but I know it's still relatively new information, especially if there's older clients out there who aren't used to social media. So Mitch, that's once again great information. And there you go. You heard it from the expert himself, Mr. Mitch Proner. That'll do it for now. And thank you for taking the time to tune in. Now, whether it's on podcast or a video broadcast, we really do appreciate you taking the time. And always remember, you can call us at 24/7 at 1-800-321-1234, where consultations are free and confidential. Excuse me. Also, if you have not done it yet, please follow us on Instagram, TikTok, Facebook, and of course, YouTube. Speaking of social media, like, share, and subscribe, and you'll get the latest updates. Now, Mitch, before we go, do you have anything else to add?
Stay off social media.
We've done that in the beginning. Cut this short. No, right. It's great. Fantastic. Well, thanks again, Mitch, for yet another informative session with you. And thank you all for checking us out. I know I learned a lot, and I also hope you did too. We'll see you next time, folks.
Thanks.
All right. Take care.
Be well.
Thank you.